Hi everyone. Hi everyone. Good evening. We are here for the CrPC session. I hope you all know that. We'll wait for 2-3 more minutes for students to join because I've just joined and I want everyone to come because this is going to be a great session. CrPC, everybody needs it, right? So I'm just waiting for 2-3 more minutes for us, all of the students to join so that we can continue with the session. Hi Harsimran. Just give me 2 more minutes. Hi, good evening, Piyush. Good evening, Sandeep. I was waiting for you all. क्यों पीयूष क्या हो गया डर किस चीज से लग रहा है आपको एग्जाम आई अंडरस्टैंड दैट बट आई एम श्योर यार इतनी प्रिपरेशन करी है तो ठीक है गॉड इज गोइंग टू हेल्प यू गॉड इज गोइंग टू हेल्प यू ऑनेस्टली Okay. So I think we'll start with the session. Students are going to join in due course of time, right? Okay, I was just waiting for somebody to join so that somebody can interact with me, right? And then we can start with the session. So here you all are. I'm glad. Okay, Sandeep. Okay, so the first question is here on your screens. Some questions are easy and there's a mixed level. I have not gone for some questions like totally easy questions के साथ नहीं गई हूँ बिल्कुल मुश्किल के साथ भी नहीं गई हूँ. So yeah, warrant case means a case in which a police officer can arrest without warrant, on which case the court in the first instance shall issue a warrant of arrest against the accused relating to an offense punishable with death imprisonment for life or imprisonment exceeding 2 years, relating to an offense punishable with death imprisonment for term not exceeding 2 years. What is the correct answer, everyone? 1C, C, C. Okay. What about everyone else? First has to be C, everyone. Perfect. Next up, next question here. Non-bailable offense implies an offense where the accused cannot be released on bail. Grant of bail is discretionary with the court, but the discretion has to be exercised on well-established principles for grant of bail. The accused may be considered for grant of bail only after the trial in the trial court begins. Only the High Court is empowered to grant bail. Non-bailable, everyone. Second is B. Perfect, everyone. Second is B. Investigation under CrPC 1973 is conducted by police, both police and court, police under discretion of the Sessions Court or the High Court. Who conducts investigation, everyone? 3A. Nidhi says A. Sandeep C. Piyush A. Soni A. Harsimran A. The answer has to be A, everyone. Only police conducts investigation. The classification of offences into bailable and non-bailable has been given in the Code of Criminal Procedure under First Schedule, Second Schedule, Section 320, Section 482. The classification of offences into bailable and non-bailable. Which schedule is it? Or which section? Question 4, everyone. Niti says A. Piyush A. Soni A. Okay, I have to agree with you all. It is A only. The first schedule. Okay, next question for you all is here on your screens. The main characteristic of the new 1973 CrPC is the separation of legislature from the executive, separation of judiciary from the executive, separation of revenue work from the executive, to provide judicial powers to the executive magistrate. 5. Nidhi says B. What about others? Everyone. Okay, A, B, D. There's a lot of confusion in 5. Question number 5, everyone. It has to be B. The separation of judiciary from the executive is the main role, the main characteristic of 1973 code. Next, which of the following combinations are correctly matched? Made by magistrate investigation. An object is to collect evidence inquiry. Ordinarily, second stage of a criminal case inquiry, and it is not a judicial proceeding investigation. Which do you think is not correctly matched? Question number 6 for you all. Okay, I think this question is incomplete. Is that the case? Yeah, the question is incomplete. We're going to skip this one. Uh, please skip question number 6. Yeah. Skip sixth question. Yeah. I had to give options. I don't know why did I miss them. Anyway, the object of investigation is to arrest the accused, to punish the accused, to collect evidence against the accused, none of the above. Object of investigation, everyone. Sandeep says C, Nidhi C, Sony C. 7 has to be C, everyone. Collect evidence against the accused. Next question. Under the scheme of CrPC, non-cognizable offences are public wrongs, private wrongs, both none. Non-cognizable. No arrest, no arrest without warrant. Public, private, both none. Mankesh says, okay. Hina says C. Okay, seventh ka C. I'm asking about the eighth, Rajay. C. Preeti says B. 8. B. Okay. What about everyone else? I hope everyone has a say in this question. Mankesh A. Sandeep B. 8th has to be B, everyone. The private wrongs are the ones which we consider that there should be no arrest without warrant. Complaint as provided under 2D can be in writing, oral, or either in oral or in writing, can be by gestures. Question number 9 for you all, very easy. G. Mankesh. 9. Nidhi says C, Mankesh C. Sandeep C, Harsimran C. Everyone says C, I'll go with C as well. Can be either in oral or in writing. Perfect. Non-bailable offense has been defined under, some questions are very easy. The starting is very easy, by the way. Non-bailable has been defined under which section? 10A, okay. Okay, the answer has to be A, everyone. It has been defined in 2A. What about question this 11 number? PP has been defined under which section? 2U, 2V, 24, 25. Where has PP been defined? 11. Nidhi says A, Sandeep A. Okay. What about others? Hina A, Preeti A, Kritika A, Piyush A. Okay, everyone. Mankesh also A. Okay, I'll go with A then. It is under 2U. PP has been defined. A case relating to an offense punishable with death, imprisonment for life, or imprisonment for a term exceeding 2 years is known as summons case, warrant case, cognizable case, non-bailable case. A case relating to an offense punishable with death, imprisonment for life, or imprisonment for a term exceeding 2 years. Very easy again. Question number 12 for you all. Sony says B, Hina B, Harsimran B, Simmer B, Piyush B. Okay, everyone. I'll go with B as well. Okay. Warrant case means a case in which a police can arrest without a warrant relating to an offense punishable with the death, imprisonment for life, or imprisonment of a term exceeding 2 years, relating to an offense punishable with imprisonment for a term not exceeding 2 years, in which the court in the first instance shall issue a warrant of arrest against the accused. Question number 13 for you all. 13B, easy. Okay, we'll go with B, very easy. Next, in subsection 24, basically subsection 1 of section number 24, after the words public prosecutor, the words inserted are one or more additional PP, two or more additional PP, at least 5 additional PP, none of the above. Which words have been introduced after the word public prosecutor in section number 24, clause 1, everyone? Sandeep says A, Sony A, Nidhi A. What about others? 14, everyone. Piyush A, Simmer A. It has to be A, everyone. Perfect. One or more public prosecutors. Next up, we have every PP, additional PP, and special PP appointed by state government to conduct a case in High Court shall be subordinate to whom? Director of Prosecution, Deputy director or prosecution, both A and B, none of the above. Every PP, additional PP and special PP, they are subordinate to Directorate of Prosecution, Deputy Director of Prosecution, both A and B. Sandeep says C, 15C. Okay. Piyush says C. Nidhi says B. Simmer says A. Okay, there's a lot of dichotomy of opinion I sense. Simmer A, Preeti A. Piyush has changed A. Tarun A, Hina A, Sony A. Okay, everyone. We'll go with A. The answer is Director of Prosecution, everyone. Both of them, all of these are subordinate to Directorate of Prosecution. Next, we have under section 29, the second class magistrate can pass a sentence up to, quick, you know it. Very easy. 16A. Okay, everyone, I'll go with A. Perfect. फाइन कितना होता है वैसे सेकंड क्लास मैजिस्ट्रेट का, कोई मुझे बता सकता है? Nidhi says 5,000 rupees. Okay. Hina says 1,000. Okay. Nidhi says 5,000 again. Okay. First class magistrate का कितना होता है? Kritika says 1,000. जल्दी बताओ, इसमें तो कंफ्यूजन नहीं होना चाहिए. Sandeep 1,000, Preeti 1,000 to 10,000. Okay. 10,000. तो अब ये तो फाइनल कर दो फिर. सेकंड क्लास मैजिस्ट्रेट का कितना है? 5 है कि 1 है? कई लोग 5 बोल रहे हैं, कई 1 बोल रहे हैं. सेकंड क्लास मैजिस्ट्रेट का पक्का 5 है. Yeah, JMIC is 10, 5K is second class. Perfect, everyone. We'll move ahead. Who can confer powers under 32 of CrPC? High Court, state government, central government, either. Either High Court or state. Quick, everyone. Question number 17 for you all. Everyone. B, D, okay. D, okay, Nandini. Piyush D, okay. Tarun D, okay, it has to be D, everyone. Either the High Court or the state government can confer a power under section 32. The law relating to jurisdiction in the case of juveniles. कौन सा section है? जल्दी. 18B, okay. Simmer B. 18B, Nandini Preeti. Okay, it has to be B, everyone. Section number 27. We'll move ahead. The Supreme Court laid down certain requirements to be followed in all cases of arrest or detention. This was held in which case? Supreme Court laid down certain requirements. कौन से केस में requirements lay down करी हैं? Vishakha's case, Keshav Nanda Bharti's, Antulya's case, and DK Basu's case of arrest or detention. Question number 19. Preeti says D. Yes, Mankesh. Piyush says D. Somebody, okay, Hina 18th का reply करिए. 19th Rajay. 19 has to be D, everyone. It is DK Basu's case for arrest and detention. Okay. Which of the following are liable under section 125 1D of CrPC for payment of maintenance to their parents who are unable to maintain themselves? Sons only, daughters only, both sons and daughters, none of the above. Who are liable under 125 for payment of maintenance? Question number 20 for you all. Please write down the question number along so that I can easily decipher as to what all are you replying to. And it becomes really difficult to make out that okay, question कौन से question का reply कब आ रहा है, because obviously there is a lag also, right? 20C, okay. C. I'll go with C as well. It has to be sons and daughters both. Okay, we move on to the next question. Section 53A of CrPC Amendment Act 2005 provides for the examination of person accused of rape by medical practitioner, Arrested person accused of rape by medical practitioner at the request of arrested person. Person accused of rape by medical practitioner at the request of police officer. Person accused of rape by medical practitioner at the request of the victim. Question number 21 for you all here on your screens. A, B, okay, A, B, there is a confusion. C also, okay. Mankesh A, C, Harsimran A, Sandeep A, okay. This one has to be C, everyone. Person accused of rape by medical practitioner at the request of the police officer. The person who is accused of rape is to be examined in 53A. 2005 Amendment Act से add हुआ है. Okay. Under 41C of CrPC, the state government shall establish police control room where? State level, district level, commissioner level, at state and district. Please tell everyone. Question number 22 on your screens now. Nidhi says 22D. We'll be covering 120 questions. Target is to complete them in less than 2 hours, around 1 hour, 30 minutes. Let's see. Mankesh, what is your answer? Sandeep says A. Preeti says D, 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 D. Okay. 22, everyone. It is D only, everyone, at state and district level both. But police control rooms are required to be made. Arrest means compulsion or physical restraint, total restraint, and complete deprivation of liberty. Both A and B, none. Physical restraint, total restraint, and complete deprivation of liberty. Both A and B, none of the above. 23. Nidhi says B. Preeti B. Nandini C. Piyush C. We'll go with B. Why? Because we believe that our physical restraint is not considered to be a part of the arrest. Hana? It is just total restraint, which might not be completely physical. That is why B is the most appropriate answer for this one. Whoever has applied B is right. Which of the following magistrate can make an arrest? Executive, district, metropolitan, all. 24. (53) रजे कंफ्यूजन आ रहा है क्या? रजे क्या प्रॉब्लम आ रहा है 50 इसमें? ऊपर चल जाते हैं, दिखा देती हूँ आपको, रुको. जस्ट कंफर्म वंस, एक मिनट रुको. यहाँ प्रॉब्लम आ रहा है ना, यहाँ देख लो. 53A of CrPC provides for examination of. क्या प्रॉब्लम आ रहा है रजे, मुझे बताओ. मे बी रिक्वेस्ट पर ही है पुलिस ऑफिसर के. ये वाले क्वेश्चन में कंफ्यूजन है क्या? 21 में कंफ्यूजन है एवरीवन? प्लीज कंफर्म. विल डील. Person accused of rape by medical practitioner. Accused person, arrested person accused of rape by medical practitioner at the request of arrested person. क्या प्रॉब्लम कहाँ आ रहा है रजे? मुझे समझ नहीं आ रहा प्रॉब्लम आप लोग का. 21 का ए लग रहा है आप लोग को. 21 A, person accused of rape by medical practitioner. Okay, 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 I get you. Right, दोनों हो सकते हैं इसके यार. ये भी तो हो सकता है at the request of police officer. पढ़ो जरा पूरा पैराग्राफ पढ़ोगे 53A का. You will find out at the request of police officer not below the rank of sub inspector. लिखा है ना संदीप, at the request of police officer. Exactly, कोई प्रॉब्लम नहीं है उसमें. मोस्ट अप्रोप्रिएट तो फिर यही बनेगा ना यार. ये तो बन ही रहा है पर्सन एक्यूज ऑफ रेप बाय मेडिकल प्रैक्टिशनर. लेकिन हम मोस्ट अप्रोप्रिएट के साथ जाएंगे तो सी ही बनेगा उसका. उसके पैराग्राफ में लिख रखा है ये लाइन, एट द रिक्वेस्ट ऑफ पुलिस ऑफिसर नॉट बिलो द रैंक ऑफ सब इंस्पेक्टर. एवरीवन, क्या 21 की कंफ्यूजन क्लियर है सबको? बताओ एवरीवन, कंफर्म सो दैट आई कैन मूव अहेड. हरसिमरन, आई अंडरस्टैंड कि आप टाइटल के साथ जा रहे थे. हो गया क्लियर सबको? Sorted. Okay. ठीक है. Perfect. Thank you. Okay, everyone. Which of the following magistrate can make an arrest? वापस आ जाइए 24 पे. Question number 24 on your screens, everyone. D, 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 D. Very easy. Come on, D. Perfect. Move ahead. Under 46 of CrPC, arrest how made? When police officer actually touches the body of the person to be arrested, when police officer actually confines the body of the person to be arrested, both only B. 25. D, C, B, B, C, D. Okay. D, D, D. Everyone, please reply. C, C. Okay. सारे ऑप्शंस आ गए, किसी ने कुछ छोड़ा नहीं है वैसे. 25 has to be C, everyone. Both. Actually touches and confines. Both. दोनों words use हैं हमारे section में 46 में. Next. Offenses not mentioned in section 320 are compoundable with the permission of higher court, compoundable with the permission of higher court, high court, Supreme Court, non-compoundable. 26, everyone. D, B, okay. Okay, okay, okay. 26. Majority is going with D. I'll go with D as well. Okay, D is the most appropriate answer, everyone. 320 के दो पार्ट्स ऑलरेडी हैं, एक विद द परमिशन, एक विदाउट द परमिशन, और नॉन, बाकी जो बच जाते हैं वो नॉन कंपाउंडेबल है. ओके. 53 ऑफ सीआरपीसी प्रोवाइड्स फॉर एग्जामिनेशन ऑफ अक्यूज्ड एट हिज ओन रिक्वेस्ट, examination of accused at the request of police officer, at the request of victim, all of the above. Be quick. याता है आपको, अभी देखा है हमने section 53 सिमिलर देखा है हमने अभी. B, perfect, perfect, perfect. Next up, we have the period of 24 hours under section 24 of CrPC includes the time necessary for journey from the place of arrest to the magistrate's court, exclusive of the time necessary for the journey from the place of arrest to the magistrate court can be excluded only with the permission of the court. No time can be excluded. Very easy. सबसे आसान basic question बचपन से करते आ रहे हैं. 28 B, okay. Yes, everyone, it has to be B. It is exclusive of the time necessary for the journey. When an investigation can't be completed within 24 hours, depending upon the facts and circumstances of each case, magistrate can order a person to remain in the custody 15 days, 60 days, 90 days, all. 29. D. Mankesh says D. Okay. Sandeep D, Simmer D, Nidhi D, Piyush D. Okay. Okay, we'll go with D. कौन सा सेक्शन है जल्दी बता दो. 167. Perfect. Next up. In which case the Supreme Court held that handcuffing is prima facie inhumane and unreasonable? Question number 30 for you all. Mankesh says B. Sandeep says C. What about others? C. Okay. C. 30 has to be B, everyone. It is Prem Shankar versus Delhi administration. Handcuffing was tagged as unreasonable and inhuman. Right against bar fetters is held by Supreme Court in MP versus Ramakrishna, Prem Shankar versus Delhi administration, Sunil Batra, या DBM Patnaib. Piyush says 31 is C. Perfect, everyone. 31 is C. Sunil Batra versus Delhi administration. In which case the Supreme Court held the rights of accused persons. Held? Maybe gave or detailed the rights of accused persons. DK Basu, Sunil Batra's, Indira Gandhi's case, Somnath's case. 32, everyone. Very easy question. Okay. Perfect, everyone. It has to be A. Rights of accused person, DK Basu. In which case it was held that under trials not to be kept with convicts. 33, everyone. Under trials not to be kept with convicts. B, okay. B, D, B, A. Balkaran says A. 33. It has to be A, everyone. It was Sunil Batra's case, where it was held that under trials are not to be kept with the convicts. Summons house served by police officer, by an officer of the court, a person authorized by public servant, any of the above. Easy. 34. Quick. D, okay. Very easy. We'll go with D only, by any of the above. Okay, next. Under which section of CrPC a person who is avoiding execution of a warrant may be proclaimed absconder? 81, 83, 83, okay. 81, 23, 83, 84. 34. D, okay. Okay, it has to be D, everyone, under section 84. Perfect. Warrants can be directed to police officer, any person. If police officer is not available, more than one police officers, all of the above. 36. 35, okay. Yellow. Yes, 82. Okay. 82 में होता है. हाँ. Okay. Do one thing. Yes. Can we just, ठीक है, इसकी जगह आप 82 कर लीजिए. Okay. Warrants can be directed to police officer, any other person. 36, everyone. Yes. 36 has to be D. Perfect. It has to be D, everyone. Next up, the powers, duties, and liabilities of a receiver appointed under section 83 are the powers, duties, and liabilities of a receiver appointed under 83 are more than mentioned in CPC, less than mentioned in CPC, equal to mentioned in CPC, none of the above. Everyone. C. Okay. 37 has to be C, everyone. Perfect. Equal to mentioned in CPC. Section 91 of CrPC talks about issuance of summons to produce document or other thing. Okay, to whom? Victim, accused, witnesses, complainant. Section 91. Simmer says C, D. Okay, C. 38 has to be B, everyone. 30 हम कौन सा कर रहे हैं? 38 कर रहे हैं ना हम, सेक्शन 91 वाला. कौन सा कर रहे हैं हम? Let me just see. 91 of CrPC. नॉट ही आएगा इसमें. इसको क्वेश्चन को कंप्लीट करने के लिए इसका आंसर क्वेश्चन बनेगा issuance of summons is not done to produce document or other thing under section 91(2). अब बताओ सब. नॉट आएगा यहाँ पे एवरीवन. इसकी फ्रेमिंग में प्रॉब्लम है 38 की. इट हैज टू बी नॉट. अब बताओ. It has to be B, everyone. Everyone except the accused can be summoned under section 91. Who can issue summons to produce document or other thing under section 91 CrPC? Please ignore all the errors. I don't know. There has been some, like while I was converting into different files, there has been some problem. I am sensing कि दो जगह आ गई है, तीन जगह आ गई है दिक्कत. Anyway, who can issue summons to produce document or other thing under section 91 CrPC? Court, any police officer, officer in charge of police station, both A and C. 39, everyone. D. Yes, it is D, everyone. Who can issue summons? Both A and B, court and any officer in charge of police station. Okay, the word inspection used in 93 clause 1 refers to things or document, locality and place, both A and B, either A and B. Either A or B. Inspection under section number 93. 1. 40C, okay, 40D, 40C. 40C, Preeti 40B. Pew says C. Okay. It has to be C, everyone. It has to be C. Locality and place and documents and things. Everything is covered under section 40. Next, security for keeping the peace. In other, keeping peace on conviction. Security for keeping the peace. In order of keeping peace. What is this? Security for keeping peace on conviction. कौन सा section है? Monkey says A. Pew says A. Okay, everyone. Okay. What about others? What do you guys think? Yes. Absolutely. 41 has to be E, everyone. It is section 106. Next. In which of the following cases it was held by Supreme Court that 125 is applicable to all irrespective of their religion? Muhammad Umar Khan versus Gulshan Begum, Muhammad Ahmad Khan versus Shah Begum. Shah Banu आ जाएगा ना. Subana alias Saira Banu and Siraj Muhammad Khan. कौन सा केस है यार? ये तो पता ही है सबको. 42. B. Okay. Yes, it is B only. Perfect. Next up. Who can not claim maintenance under 125? Wife able to maintain herself, legitimate or illegitimate, minor child, father or mother, none of the above. Who cannot claim maintenance? 43. A. Okay. A. Sandeep says A. What about others? Piyush A. Harsimran A. Mankesh A. Okay, everyone, it has to be A. It is wife unable to maintain herself. Next. In which cases it was held by Honorable Supreme Court that a married daughter is also liable to maintain her parents. Vijay Manohar Arbat, Savita Ben, Kirti Kant Vadodaria, NB Bhikshu. 44, everyone. Sandeep says A, Nidhi says A. Preeti, you will find out in that section, especially it has been mentioned that there is going to be, there is a word written with regards to document and thing also. Clause B, I think 93 का B में जाके कहीं पे आपको दिख जाएगा. Okay, where were we? 44 पे है ना हम? 44 is has to be A, everyone. 44 is A. Vijay Manohar Arbat versus Kahi Rao. Is it Kashi Rao or Kahi Rao? I don't know. Okay. A stepmother can claim maintenance under section 125 from her stepson, provided she is childless and widow, provided she is childless and her husband is incapable of supporting and maintaining her, provided she is childless and her husband is capable and her husband is capable of supporting and maintaining her, both A and B. 45, everyone. B, D, okay. D, C, okay. D. The answer has to be D, everyone. Both A and B, she is childless, she is a widow, or her husband is there, but she is unable to maintain the stepmother, then the responsibility was on the stepson. Next up, who is authorized for removal of public nuisance? Executive magistrate, judicial magistrate, second class, first class, district and session judge. Removal of public nuisance, everyone. Section of question number 46. Sandeep says C. Puneet says A. Piyush says A. It has to be A, everyone. It is executive magistrate's responsibility. Any dispute relating to possession of immovable property is decided by judicial magistrate, executive, either judicial or executive, neither judicial nor executive. Question number 47, everyone. Sandeep says 47A. Sandeep, Piyush says A. Simar says C. Everyone? 47A, okay. अगर ये डिस्प्यूट, एक बार दिमाग लगाओ वैसे, अगर ये डिस्प्यूट उससे बाहर हो रहा हो, मतलब कोर्ट में जाने की बात ना करी गई हो और बाहर ही डिसाइड करना हो ये डिस्प्यूट, तो किसके सिर पड़ता है ये? याद है? Yes, Puneet. Exactly. एग्जीक्यूटिव मैजिस्ट्रेट। वैसे क्वेश्चन में स्पेसिफाइड नहीं है तो ए के साथ भी जनरली तभी लोग जा रहे हैं। I understand their confusion here. No order issued under section 144 CRPC shall remain in force for more than 15 days, 1 month, 2 months, 7 days. 48C, okay. Yes, Munit, 145. 48C, C, okay, C. It has to be C, everyone. 2 months is the time period. Which chapter of CRPC deals with preventive action of the police? Preventive action of the police, everyone. Sandeep says B. Nandini B. Puneet 49A, okay. Tamanna B, Preeti B. Preventive action of police, everyone. It has to be B, everyone. Okay, we'll move ahead. Under section 153 of CRPC, who can inspect the weights and measures? ये क्वेश्चन बहुत आता है, पता नहीं क्यों. 50. Sandeep says C. Simmer C. Harsimran C. Piyush C. Okay, we'll go with C. It has to be police officer in charge of police station. Perfect. Next. During investigation, a search can be conducted without warrant by any police officer, investigating officer, both, either A or B. 51 for you all. B. Okay. Nidhi says C. Puneet says B. Piyush B. Mankesh B. 51 has to be B, everyone. The investigation officer. Next, the inquest report must contain names of the accused, the apparent cause of death, details of weapons, details of incident. 52. Sandeep says B. Nandini B. Puneet B. Okay, everyone, we'll go with B. The apparent cause of death. Perfect. The refusal to answer question put to a witness under 161 of CRPC is an offense under which section of IPC? Harsimran says 53B. It has to be B, everyone. Section 179 कितनी सजा है? सिंपल इम्प्रिजनमेंट कहां तक 6 months और साथ में 1000 तक फाइन, यही है ना? Yes, perfect. Next. In which case the Supreme Court has issued the guidelines for issuing non-bailable warrants? Dinesh Dalmia, Inder Mohan Goswami, Mohammad Ahmad Khan, none of the above. 54, everyone. Sandeep says A. Nidhi says A. Soni A. Piyush A. Puneet A. Mankesh A. The answer is A, everyone. 54, Dinesh Dalmia versus CBI. Okay. Next up, which is true about recording a confession by a magistrate? A police officer should be present so that the accused may not flee. A magistrate should warn that it is not necessary for the accused to confess. Prior to the confession, he should be left in police to confession. He should be left in police custody for some time. All of the above. 55, everyone. It has to be perfect. The magistrate should warn it is not necessary for the accused to confess. This is the most appropriate answer. A non-confessional statement recorded under 164 of CrPC is a substantive piece of evidence, is not a substantive piece of evidence, may or may not be substantive depending upon the facts and circumstances of the case, all of the above. Non-confessional statement, everyone. '56. B, perfect, everyone. 56 is B only, not a substantive piece of evidence. Mentioning name of the witness in the FIR is necessary, not necessary. If not mentioned, whole proceeding is vitiated. None of the above. 57, very easy. B. Yes, not necessary. Perfect. Next, mark the incorrect statement. FIR can be lodged only in the case of cognizable offense. It can be lodged to an officer in charge of police station. It can be used as corroborating or contradicting evidence. It is a substantive piece of evidence. 58. Pew says D, Puneet D, Mankesh, Sandeep, Nidhi. Everyone says D. Okay, yes. FIR is not a substantive piece of evidence. Okay. Section 156, clause 2 of CrPC cures any irregularity in the conducting of investigation by police, any illegality in conducting of investigation by the police, both, neither. 59. Piyush C, Sandeep C, Nidhi A, Sony C. It is C, everyone. 59 has to be C, both A and B. Any illegality, any irregularity, everything is cured under 156. कहते कोई चक्कर नहीं है. What is not contemplated by section 441? Furnishing of a personal bond by the accused person, a bond by one or more sufficient sureties, a demand of cash security by a magistrate, affidavits relating to the sufficiency of sureties. What is not contemplated by section 441? Question number 60 for you all. C, okay. Sony C, Nidhi C, Pew C. It has to be C, everyone. A demand of cash security by a magistrate is not contemplated. For an irregularity not to vitiate a proceeding, what is needed is good faith. Irregularity should not occasion a failure of justice. Both A and B, only B. This question is 61, everyone. The question number is wrong. It is 61. Yeah, question number is here. 61, everyone. Irregularity not to vitiate a proceeding. What is needed? C, B. Okay. 61. 61 has to be C, everyone. Next. 62. 162 of CrPC applies to statement recorded by police officer investigating the case during the investigation by witness, accused, both, neither. '62, everyone. Sandeep says C, then Sandeep says, okay, Sandeep says B. 62. Urvashi says C. Piyush B. Puneet C. Nidhi C. It has to be C, everyone. Both A and B, witness and accused. Under section 162, clause 1 provides that statement of a witness can be used for the purpose of contradicting the witness. If it is reduced in writing, it is not reduced in writing, it is oral, all of the above. 162 clause 1, everyone. Okay. Statement of a witness can be used for the purpose of contradicting. It has to be A, everyone, if it is reduced in writing. Okay. No court shall take cognizance of an offense after expiry of period of limitation, which is 6 months if offense is punishable with fine only, 1 year if punishable with imprisonment for a term exceeding 1 year, 3 years if punishable with imprisonment for a term exceeding 1 year, but not exceeding 1 year, but not exceeding 3 years. It has to be not exceeding 3 years. All of the above. Sandeep says D, okay. The answer is D, everyone. Section number 468 nahi hai ye. This is section number 468. Next up. Confession or statement made under section 164 can be recorded in a police custody, in a jail, in audio, video, electronic means by letter. 65, everyone. Perfect. It is C, everyone. By audio, video, electronic means. Administration of an oath before recording of the confession is necessary, is not necessary, is dependable on discretion, all of the above. Administration of oath, everyone. Sandeep B, Tamanna C. Simar B, Nidhi B. 66. B. Okay. It has to be B, everyone. It is not necessary. 164 key confession is not under oath, everyone. A person arrested without a warrant cannot be detained by the police for more than 24 hours. However, if the police considers it necessary to detain such a person for a longer period for the purpose of investigation, he can do so only after obtaining a special order of a magistrate under which section? Very easy. 67. B, okay. Yes, it is B only, section 167. Next. Under which section of CrPC, when rape is alleged to have been committed on any woman, while such woman is in custody of the police, it is obligatory for the nearest magistrate to hold an inquiry. Which section is it, everyone? 68, Nidhi says C. Sandeep says D. Soni says C. Simmer C. Question number 68, everyone. It has to be C, everyone. सेक्शन नंबर 176 का 1A आगे जो है वहां पे है ये प्रोविजन. Next we have question number 69 under section 198 of CrPC. No court can take cognizance of an offense punishable of an offense against marriage unless a complaint is made by who has to complain under 198? 69 na? Right. Yeah, 69. ठीक है order. Sandeep says B, Simmer D, Sandeep B, Simmer D. Okay. Nandini B, Soni B. 69. B. देख लो कुछ और तो नहीं कहना. अच्छा D. Yeah, everyone, it has to be C. पहली लाइन ही लिखी हुई है यार, क्या हो गया? Yes. Under which of the following sections of Code of Criminal Procedure a court of sessions has the original jurisdiction to take cognizance? Court of session की original jurisdiction. Question number 70 for you all. Nidhi A, Sandeep A. Sandeep, Simmer, Lazy Panda, Soni. everyone. Section A, option A. Okay, Piyush. Breathe A. Okay, the answer is A only. It is section number 199 for you all. Next up, we have 9071. Which one of the following statement is not correct? The term charge is defined in 2B. Charge should be clear and specific. It must refer to the section of IPC under which the offense charge is punishable. There is no need to write the charge in the court's language, which is not correct, everyone. 71 for you all. Okay. 71, everyone. It has to be D. Perfect. There is no need to write the charge. This is wrong. Once an accused is discharged under 222 or 239 CrPC, he cannot be tried again for the same offense. It amounts to an acquittal. The judge need not spell out any reason. He cannot be tried again for the same offense if sufficient evidence is brought forward later. 72. सोच के बोला करो, इतनी जल्दी जवाब देने के चक्कर में ना बहुत सारे लोग गलत जवाब देते हैं और बाद में फिर करेक्ट करते रहते हैं. सोच टाइम ले लिया करो. लंबे क्वेश्चन में टाइम लो एटलीस्ट. ADDB. Yes, it is D, everyone. Question number 72, everyone. It has to be D, the most appropriate answer. Mark the correct statement. Non-appearance of the complainant himself is a valid ground for discharging the accused under section 245 clause 2. Normally, a person cannot be discharged unless the prosecution evidence has been taken. The magistrate is also empowered to discharge the accused at any previous stage of the case if he considers the charge to be groundless. All of the above. 73, everyone. I can't get what you're saying, Puneet. किस सेंस में आपने बोला कि it is distinct reference? I किस question के reference में? I just missed it. 73, everyone. 73. Okay, perfect. It has to be D, everyone. All of the above. Okay. Hearing on sentence by magistrate is required on conviction. In a summons trial case under 255(2), in a warrant trial under 248(2), both, neither. 74, everyone. Okay, Puneet, I'll check back maybe later. 74. Oh, yes, you're right. I get you. I get your points, Puneet, now. Yeah. Question number 74 for you all. Be quick. D, okay, 74 is C. Piyush says C. What about others? 74. Hearing on sentence. Summons trial की कहाँ पे है? मेरा warrant की कहाँ पे है? दोनों की सही है क्या ये? The answer is C, everyone. Both A and B. Summons की है 255 में ही और warrant की है 248(2) में ही. Mark the incorrect statement. Where an accused is charged with two offences, one of which is triable summarily and the other one is not, the magistrate can discard the later charge and try the accused summarily. In summary trial, former charges should be framed, both A and B, neither A nor B. 75. Which is the correct answer? Quick. Piyush says A. Nidhi D. Sony A. Piyush C. Harsimran A. 75. Everyone. Last chance. You want to change your answers? You want to give your answers? C would be the most appropriate answer, everyone. Both of them are partially incorrect. Plea bargaining under Indian law implies bargain for declaration that the accused is innocent, bargain for dilution of the charge, bargain for lesser punishment or release on probation of the accused, plea for lesser punishment and dilution. 76. Plea bargaining implies what? Everyone. Pankaj, no. Where is PP defined in 24? The appointment and the process has been given in 24. 76. C, everyone. The answer is C, everyone. Bargain for lesser punishment or release on probation. The court can record a demeanor of a witness. बहुत बार आता है, बहुत easy भी है. Which section? 77 question. Which section? Say everyone perfect. Section 280. Under section 313 of CrPC, no oath shall be administered to the accused when he is examined. The accused shall render himself liable to punishment by refusing to answer questions or by giving false answers to them. The answers given by the accused cannot be taken into consideration and put in evidence for or against him in any other inquiry, trial, or any other offense. Every error or omission in complying with 313 necessarily vitiates the trial. बताइए. 78. Puneet says A, Urvashi says okay, A, Nandini A. The answer is A, everyone. 78. No oath shall be administered to the accused when he is examined. Okay. Mark the incorrect statement. Section 319 of CrPC could not be invoked when the trial has not begun and no evidence has been recorded. The power to proceed against a person not named as an accused is to be exercised sparingly and for compelling reasons. The provisions of 319 of CrPC applies to all the courts, none of the above. 79, everyone. D, okay. Accused के अलावा जब किसी को ऐड करना होता है वो वाला है. The answer is D, everyone. All of these are correct. An offense of voluntarily causing grievous hurt by dangerous weapon or means as given under 326 of IPC. It is compoundable, non-compoundable, compoundable with the permission of the court, none of the above. 80, everyone. कैसे हो सकता है पीयूष? नहीं, it is not incorrect. वहां पे लिखा है एनी टाइम. Okay, let me just check once. एक वर्ड में गलती हो सकती है. Okay, so you got it ना? It's fine, it's fine. 80 का बता दो. An offense of voluntarily causing grievous hurt by dangerous weapon or means as provided under 326 of IPC is compoundable, non-compoundable, compoundable with permission of the court, none of the above. Section 80, everyone. Question 80. Got you, got you. C, B, C, okay. B, okay. Ask the B. Puneet C. 80. Everyone. Harsimran B. Please, everyone, be a little quick. It is not compoundable. Everyone, all of you, जो भी compoundable बोल रहे हैं, कहाँ लिखा है यार? मुझे भी ढूंढ के बता दो. It is not compoundable, Ajay. Consider the following statement regarding providing legal aid to accused at state expenses. Legal aid is the right to the accused, charity by the state, available in the trial before session court, only available in all trials. Which of the statement is in the given case is correct? 1 and 2, 2 and 3, 1 and 3, 2 and 4. 81. Quick. Asdeep says C. What about others? What about others, everyone? Question number 81. Nidhi C. Urvashi C. It has to be C, everyone. It is available in the trial. Sorry. Both of these are correct, I mean. Okay. We'll just delete what's there. Yeah. 1 and 3. Right to the accused and available in the trial before session court only. Section 315 of CrPC relates to the accused person as competent witness. With regards to this, which one of the following statements is not correct? Please read these and answer this. 82, everyone. Okay. '82. A, everyone. Answer has to be A. Next up, which of the following offences is not compoundable? 323 IPC, 334, 448, 307. 83. D, okay. Yes, everyone, it is D, attempt to murder. Next. The composition of an offence under 320 CRPC shall have the effect of conviction, discharge, acquittal. It will finish the case. The composition of an offence under 320 shall have the effect of 84, everyone. C, perfect. It will have the effect of acquittal. Who can withdraw a case from prosecution under 321 CRPC? 321. Question number 85 for you all. Puneet says B. Okay, the answer has to be B, everyone. The public prosecutor in charge of a case with the permission of the court can withdraw the prosecution. Whether an accused may be a competent witness in his own defense. If he applies in writing on his own request, no, with the leave of the court of session, with the leave of high court. 86. A, okay. A, perfect, everyone. It's A only if he applies in writing and that on his own request. In which of the following cases the right to speedy trial has been recognized? Hussain Ara Khatun, Tarlok Singh, Surjit Singh, State of Bihar versus JSC, Sardana. Speedy trial, everyone. Question number 87 for you all. A, perfect, everyone. It is A only. Hussain Ara Khatun versus State of Bihar. Under section 311 CRPC, a witness can be called on the motion of the prosecution, on the motion of the defense, on its own motion by the court, all of the above. 311 CRPC. 88. D, okay. D, C. I'm sorry. Everyone, please be quick. 120, Puneet. We are at 88. We are left with around 40. 30. Please answer this one, everyone. 88. Answer has to be C, everyone. Most appropriate answer would be C. Okay, next. Which section CRPC of CRPC gives power to magistrate to order a person to give specimen signature on handwriting? 310A, 311B, 311A, 312A. Specimen of handwriting, everyone. 89. The answer has to be C, everyone. 311A. Okay. Rules of autrefois acquit autrefois convict is contained in which section? 90. बहुत बार आता है ये भी पता नहीं क्यों क्वेश्चन. Very repetitive. C. Perfect, everyone. It's C only. Section 300. Next up. Mark the incorrect statement. The English doctrine of autrefois acquit has been fully incorporated in 300. The dismissal of a complaint or discharge of the accused in an acquittal for the purpose of okay, the dismissal of the, there is some, I think, misframing of the answer of the option. A wrong or erroneous order of an acquittal will bar a subsequent trial. I think you can understand this well. Which is incorrect. Everyone. 90 for you all. 91, 91, 91. D, yes. दो भी पता लग रहे हैं उससे मेरे को जवाब तो पता लग ही रहा है. It has to be D, everyone. Both of them are incorrect. In case we are unable to understand the second option. Mark the incorrect statement again. Under section 311, a magistrate is competent to summon any person as a court witness. Under section 311, additional evidence can be permitted to be produced even after the defense has been closed or arguments heard before giving of the judgment. Under section 311, court can examine any person in the attendance who is present in the court, although not summoned. None of the above. 92, everyone. Take your time. 92, everyone. Be quick. It is D only. Perfect, everyone. Next up. Mark the incorrect statement. The power under section 3 incorrect mark करनी है, ठीक है? The power under 309 does not include a power to direct the payment of costs by a party whose conduct has necessitated the adjournment. 311 is limited only for the benefit of the accused. 313 applies to maintenance, all of the above. Incorrect, everyone. Question number 93 for you all. 93. Mark the incorrect statement. Everyone be quick. Yes, everyone, it's D only. Okay, we move ahead. Mark the incorrect statement again. Please read the question. 94 is on your screens. 94 for you all. Please write down the question number side by side, everyone. भूल गए हो? Piyush D, Sony D, Simmer D, Puneet D, 94 everyone. 94 has to be D everyone. Perfect. Next up, under section 309, the magistrate may remand the accused to the custody for how much time? Please see. 95. 95 everyone. Just please see. Perfect everyone. It has to be not exceeding 15 days at a time. Okay, next up we have under which section session court exercises power of appeal from conviction. 96 for you all. 96. C, C, C. Okay. 96 has to be C everyone. Section 374. Next up, abatement of appeals is provided in a which section? Abatement of appeals. Question number 97 everyone. A, okay. A. Perfect everyone. It has to be A. 394. If an order of acquittal is passed in any case instituted upon complaint, the complainant may present such an appeal to the Court of Session, CJM, special judge, to the High Court, if special leave is granted by High Court. Question number, everyone. 98. A, okay. A. 98, everyone. Be quick. It has to be A, everyone. Next up, and anticipatory bail may be granted. Anticipatory bail may be granted. प्लीज बताइए इसका राइट मोस्ट अप्रोप्रिएट आंसर क्या होना चाहिए. $99C A. Okay. A C A. Okay. A. Okay. Everyone, please confirm. Really bad throat. आप questions खुद ही देखिए, खुद ही जवाब दे दें. I'll just confirm. I'll just check again. Give me 1 second. 98, if any order of acquittal is passed in any case instituted upon complaint, the complainant may present such an appeal to the Court of Session, CJM, special judge, High Court if special leave granted by High Court. Right. You're right. It has, please change everyone. It has to be D. The High Court if special leave is granted by High Court. 98 का most appropriate answer would be D, everyone. 99. Anticipatory bail may be granted. 99. Jaspreet says A. 99. A. C. Okay. दे हैड बोथ का ऑप्शन होना चाहिए कि यहाँ पे मोस्ट अप्रोप्रिएट ए और सी दोनों जाएंगे. अगर इसका बोथ का ऑप्शन होता बोथ ए एंड सी वुड हैव बीन द मोस्ट अप्रोप्रिएट ऑप्शन एनीवे. इट्स मिसिंग. सो या. Anticipatory bail implies what? Please read them and answer them, please. Question number 100. 100, everyone. 100 has to be C, everyone. It has to be C. Okay. Next up. A metropolitan magistrate is equivalent to what? JMIC, JM second class, either A or B? None. 101. A. Okay. A. Yes, easy. A only. Okay. A sessions judge under 9 clause 2 is appointed by 102. C. Okay. What about others? Please answer, everyone. C, C, C. Okay, okay, okay. We'll go with C, everyone. It is the High Court. Next up. Which of the following is the duty on the members of the public to assist a magistrate or police officer when reasonably called to do? In the taking or preventing the escape of an offender, in the prevention or suppression of the breach of peace, in the prevention of injury to railway, canal, telegraph, or other public property, all of the above. Very easy. 103. 103. It has to be D, everyone. 103 is D, all of the above. Next up. A proclamation against a person shall be published in which of the following modes? Public reading in town, village, where the person ordinarily resides, affixation to such person's house or conspicuous place of such town or village, publication in daily newspaper, all of the above. 104, everyone. Sony D, Piyush D, Puneet D. Okay, okay, okay. Everyone says D, so I'll go with D, obviously. It is the correct answer. Next up, we have the period of limitation for filing claims and objections by persons other than the proclaimed person in the property attached is how much time? The period of limitation for filing claims and objections by persons other than the proclaimed persons. 105, everyone. C, C, C. Yes, the answer has to be C, everyone, within the 6 months from the date of attachment. Mark the correct matching. Please, everyone, please read them once. कुछ सही है, क्या सही है? Search of witnesses आना है. Search of person, search of witnesses, signature and attendance. None of the above. 106. क्या हुआ, किसी को नहीं आ रहा? 106 has to be D, everyone. None of the above. Next up. Which section empowers a police officer to seize any property which is alleged or is suspected to be stolen or which may be found under circumstances creating suspicion of the commission of an offence? One zero seven, everyone. One zero seven. B D B. 107, everyone. It has to be B. Section 102. Next up, a conditional order for removal of public nuisance under 133 CrPC may be passed by DM, SDM, executive magistrate, any of the above. Subdivisional magistrate, district magistrate, executive magistrate. 108 question number. D, D, A, D, D, D. Okay, the answer has to be D, everyone. Any of the above. तीनों का नाम लिखा गया वहाँ पे. Urgent cases of apprehended danger or nuisance contemplated by 144 does not include obstruction, annoyance or injury to any person lawfully employed, danger to human life, health or safety, improvement to the public drainage system, disturbance of the public tranquility or a riot or an affray, which is not included. 109. C. 109 everyone. It has to be C everyone. Improvements to the public drainage system. Perfect. Next up we have, which of the following is the leading case of an anticipatory bail? 110 everyone. A. Okay. The landmark here has to be Good Boxing Sibia. Next up we have, every judgment referred to in section 353 of CrPC shall be written in the language of the court, accused, complainant, none. Very easy. One it is. Very easy. A. Okay. Okay. Next up, as provided under section 353 clause 6 of CrPC, where there are more accused than one and one or more of them do not attend the court on the date on which the judgment is to be pronounced, the presiding officer may. Please read the options and get back everyone. 112 for you all. Puneet says B. Piyush B. Urvashi B. Sony B. 112. It's B everyone. Pronounce the judgment notwithstanding their absence. Perfect. Next up, the victim compensation scheme was introduced by, important question, commonly asked question basically. 113. Easy one it is. Question number 113. It is C everyone. 113 is C. 2008. Okay. Which of the following sections of CrPC mandates that no appeal shall lie from any judgment or order of CrPC of criminal court except as provided for by this court or by any other law for the time being in force? No appeal shall lie from any judgment. Section number 114. Question number 114. Simmer says B. Okay. One one four has to be B everyone. In which of the following cases the victim or his dependents may make an application to the state or the district legal service authority for award of compensation? 115. Last 5 questions. Puneet says C. Everyone. C, B, okay. Please, everyone, please answer. 115 has to be B, everyone. C is not the right answer. 115 का appropriate answer बनेगा B. Most appropriate answer. Where a high court passes only a sentence of imprisonment for a term not exceeding appeal, will lie against it. Okay, what is this formation? Where a high court passes only a sentence of dash of imprisonment of a term not exceeding how many months, appeal will lie against it. ऐसा करके लीजिए आप. Yes. Yes, Piyush, not exceeding. 116. Where a high court passes only a sentence of. We can skip this question as well if it doesn't make sense. I think it quite. If you try to reframe, then it's going to definitely make sense. Where a high court passes only a sentence of imprisonment of term not exceeding this, not exceeding this. ऐसा आएगा. Okay. 116 for you all. 116 has to be B, everyone. 6 months. Mark the incorrect statement. Please read it and mark the incorrect statement. Please tell me 117. Yes, Piyush, I understand that there was some error. 117. B. Okay. B. B. Okay. ये सही है क्या? A pardon may be granted by the CGM, Metropolitan Magistrate और First Class Magistrate. ये सही है, बता दो बस इतना. Sorry. Okay. और ये सही है पुनीत. The answer has to be D, everyone. Yes. Any person who has accepted a tender of pardon made under section 306 or 307 has either by willfully concealing anything essential or by giving false evidence not complied with the condition on which the tender was made. Who will certify this fact? 118. Nidhi says C. The answer has to be PP only. C is the correct answer, Nidhi. Second last question for you all. I'm sorry, I'm running low on energy because of ill health. Section 309 provides for speedy trial, remand to custody, adjournments of proceedings, inquiries, and trials, all of the above. Section 309, everyone. everyone. सोच के बोला करो यार सभी क्वेश्चंस आंसर चेंज करते रहते हो बाद में खुद ही. C A A C C okay. Somebody was B also. C D. Most appropriate answer is D, everyone. All of the above. Read the section once again, you will find out how. Last question. Under section 309 clause 2, the magistrate may remand the accused to custody for how much time? A period not exceeding 7 days at a time, a period not exceeding 14 days at a time, a period not exceeding 15 days at a time, a period not exceeding 1 month at a time. 120. Nidhi says C. Piyush says C. The answer has to be Puneet C. Jaspreet C. Okay, the answer has to be C, everyone, not exceeding 15 days at a time. This is all. For the last set of questions, couple of questions, I had to obviously, I was not, my throat is not well today. It's, I have a, like obviously, scratchy throat today. I'm sorry if I wasn't energetic enough, but thank you for all those who stayed, and thank you for all those who have been keeping up with all the answers. And I am sure you might have learned all your mistakes, and you'd work on them. And in case you need any other help, you can just text me on the numbers. You can text the team rather on the numbers that are given below, right? So also for PDF, please download our application, which is AIM Pariksha, and you'll find it on Play Stores and everything, right? So thank you very much. Thank you, Piyush. Thank you very much. Thank you. Thanks for all. Thanks to you all, rather, right? Thank you. Take care of yourself, and I wish you all very best. I'll, if I am fine, I'll be conducting, taking mock tomorrow. This may I'll try to cover all the subjects maybe. So we'll see what happens tomorrow. We have covered CPC so far. We have covered CRPC. We have covered Evidence Act. We have covered Sale of Goods Act, Limitation Act, Partnership Act, Specific Relief Act. We have covered a lot, right? We have covered around 9 subjects, 9 subjects so far. So whatever we are left, yes, I am hoping, Piyush. God bless you all. Take care of yourself, and yeah, you will know in case we have a class tomorrow also for the quick revision of all the subjects. I mean, mocks, right? Okay, take care of you. Take care, everyone. I'll take your leave. Bye bye. Thanks to you, Nandini. Thanks to you all who were there attending the session with me.